Good morning.
Good morning.
All right, WBZ, I'm going to shift you a tad. I don't think I'm going to mess you up here.
Thank you.
You're welcome. Thank you, and good morning, everyone. Thank you for being here. First, I just want to talk about who I'm joined with today. So I'm joined today by leaders in the housing, workforce, and business sectors, including the Executive Director of Abundant Housing Massachusetts, Jessie Canson-Benanav, the President of Massachusetts AFL-CIO, Chrissy Lynch, the President and CEO of Associated Industries of Massachusetts, Thompson, and Rachel Heller, who is the CEO of Citizens Housing and Planning Association. So I'm delighted that they are here with me and grateful for your leadership. You will hear from them shortly, specifically about how our Commonwealth's housing crisis is affecting residents, workers, businesses, and more, and why the MBTA Communities Law is a powerful tool to help us alleviate that crisis. These are just some of the 70 organizations who filed friend of the court briefs in our case against the town of Milton. They endorse our arguments that this law is mandatory and is a critical tool to addressing our long-standing housing crisis. Housing affordability is the #1 challenge currently facing Massachusetts and Massachusetts residents. The median price of a single-family home here in Massachusetts is almost $1 million. The lack of affordable housing is driving people out of our great state. It's making it tougher for teachers, nurses, first responders, and public servants to call the Commonwealth their home. It's squeezing young families, making it hard for them to stay in the neighborhoods they grew up in. It is hitting our elders who are on fixed incomes, forcing them to choose between living near loved ones or having access to basic amenities. And if we can't house our workforce, we cannot grow our economy. And that is an issue that affects each and every one of us. Today marks a pivotal moment as we begin oral arguments against the town of Milton for failure to comply with the MBTA Communities Law. I hope many of you will head over to the court after this to listen to those arguments. This is an important case for two reasons. One, to ensure the effectiveness of the MBTA Communities Law as a tool to addressing our housing crisis, and to protect the rule of law and uphold our legal structure here in Massachusetts. No one should be able to pick and choose which laws they want to comply with. And I hope the court will see the significant consequences of continuing to allow Milton's non-compliance. I did not make the decision lightly to sue a municipality. For months we attempted to work with Milton to assist them with compliance, just like we have and will continue to do so with other municipalities covered by the law. In March of last year, my office issued an advisory to clarify what this law demands, that it is mandatory, and the consequences of non-compliance. Since then, we have rolled up our sleeves, providing resources in plain language, not legalese, making referrals for technical assistance, collaborating on zoning plans so communities get our feedback before they vote, not after. And I want folks to remember that this law does not require communities to embrace a one-size-fits-all approach. It creates more zoning districts where housing can be built, and it gives communities significant discretion about the size and the location of that district. In fact, the town of Milton developed a compliant zoning district with support and funding from the state, but private individuals brought a referendum that overturned it. Our argument is very simple. When the statute says that covered communities shall create a compliant zone, shall means shall. The town of Milton cannot avoid that requirement. As the Chief Law Enforcement Officer of the Commonwealth, it is my responsibility to enforce the laws on the books, including the MBTA Communities Law. And to be clear, we'd much rather collaborate with the community than take them to court. We're all about partnership and collaboration in this office. But when a choice is made to break the law, my office will be ready to meet our obligation to enforce it. The housing crisis isn't just a local issue or an issue for one municipality. It's a statewide emergency that absolutely demands a statewide response. And there are dozens of communities that get that. Just last week, I was proud to join the Healy-Driscoll administration to celebrate the momentum behind the law. Now there are 76 communities acting in good faith to embrace new zoning and follow the law. That includes 36 fully compliant communities. Of the communities that have voted to date, 85% have supported compliance. And we expect another wave of compliance this fall. In fact, as we all enter town meeting season, it's my hope that the communities still left to vote on this critical issue will join our expansive and diverse coalition. They'll see that our approach is reasonable, flexible, and collaborative, that we stand ready to work with communities working to come into compliance. And to everyone who lives in the community covered by this law, I urge you to take action to help your community meet its housing needs and the housing needs of our Commonwealth. My office and I will continue to provide resources to each community in the Commonwealth. I particularly want to thank Margaret Hurley, Esme Caramello, who assist towns every single day as they are working to come into compliance, and the litigation team that is on its way over to the courthouse now for the work they have done in this case, including Eric Haskell, John Burke, and Erin Fowler. Now please join me in welcoming Jessie from Abundant Housing Massachusetts to the podium. Thank you.
My name is Jessie Kansen-Benenov. I'm the Executive Director of Abundant Housing Massachusetts. We are a coalition of neighbors from across the Commonwealth who proudly say yes to more homes in our backyards and our communities. And I want to thank Attorney General Campbell for this opportunity to speak and for her critical leadership on this issue. For far too long, the responsibility to meet the changing housing needs of our state's residents has fallen to a small handful of communities, while many others have used restrictive zoning to put up figurative walls and block the freedom of other people to move where they want and when they want. This restrictive zoning has caused the extreme shortage of over 200,000 homes we now face as a Commonwealth. It's the reason why, as the Attorney General mentioned, the median home price in Greater Boston is now approaching $1 million, far out of reach for so many people in our Commonwealth. At Abundant Housing Massachusetts, we believe strongly that an affordable and equitable future for our Commonwealth and its residents depends on every community doing its part to meet our growing housing needs. The MBTA Communities Act is a cornerstone of this approach. That's why Abundant Housing added our voice to support the Attorney General with an amicus brief in this case that includes a comparative analysis between Massachusetts and other states that have recently passed state-level bills aimed at responding to their housing shortages with far less deference to the local decision-making processes that the MBTA Communities Act provides. At Abundant Housing Massachusetts, we recognize the importance of local community organizing to build a grassroots base of pro-housing advocates across the state to fight for more affordable homes and inclusive communities. In the last 2 years, we've worked with dozens of communities across the region and residents to educate their neighbors about the importance of this act and of their community doing its part to meet our state's housing challenges. These advocates include folks like Ruth, a senior citizen and longtime resident of Marblehead who wants to downsize in her town but can't because there simply aren't affordable and accessible options for her. She has joined with local pro-housing advocates in hopes that she can advocate for more housing for other seniors in situations like hers today and into the future. Or James, a Southborough native and a leader in the local pro-housing group Southborough for All, and a current college student in DC who traveled home this past Monday simply to witness and vote in Southborough's town meeting victory that would have not been possible were it not for the grassroots tactics and mobilization of Southborough for All. James is helping to ensure that his town remains a place where he can move back to after college. In partnership with Attorney General Campbell, the Healy-Driscoll administration, with the other organizations represented here today, and thousands of residents across the Commonwealth, we will continue to build a multi-generational and geographically diverse coalition to uphold the importance and effectiveness of the MBTA Communities Act as a key solution to our state's housing crisis. Only together, with every community doing its part, can we make the vision of an inclusive, sustainable, economically competitive, and affordable Massachusetts a reality for everyone. Thank you.
This this time, I'd like to invite up Chrissy from the AFL-CIO.
Thank you, Attorney General Campbell, for your leadership on this and so many issues. My name is Chrissy Lynch. I am the president of the Massachusetts AFL-CIO. With nearly 500,000 members across the state from pretty much every sector, we have seen the housing crisis and how badly it impacts working people. We are proud to join over 70 other organizations in submitting a brief in support of the AG's authority to enforce this really important act. While we think a union job is still the surest path to securing a life in the middle class, rising rents and rising home prices have put the dream of home ownership out of reach for so many working people. Housing accessibility, affordability, and security are an issue we hear about from union members all of the time. This is an issue of economic justice. The Massachusetts labor movement is committed to delivering a more equitable economy that works for working people, whether they're at home or after or at work. Union members need housing. Union members build housing. Union members also run the T, and union members also need the T to get to and from where they're going. It's really crucial to the labor movement and the union movement in Massachusetts that we care for our members on the job site and at home. And stable, affordable housing is a top priority in making that a reality. Dense, multifamily housing in close proximity to public transportation is critical to opening the doors of new opportunities for career paths, for training, for access to healthcare, for access to education, and it ensures that our communities across the state remain connected. As we tackle our state's housing crisis, the integrity of innovative, solutions-driven laws like the MBTA Communities Act must be protected. We are really proud to stand in solidarity with the AG and her team to continue the fight for an economy in Massachusetts that works for working people. Thank you.
Thank you, Chrissy. This time, I'd like to invite up Rachel to speak.
Thank you, Attorney General, for this lawsuit and for enforcing this critical law. I'm Rachel Heller, the CEO of CHAPA, Citizens Housing and Planning Association. We work with people all across the state to promote the production and preservation of homes that are affordable for people with low and moderate incomes. And together we work to ensure that everybody has a safe, healthy place they can call home in the community that they choose. For too long, zoning has been used to say no to housing and to keep people out. And this is now impacting every single one of us. Our local land use policies are holding us back. By saying no to housing, we create half the number of homes today than we did in the 1980s. Meanwhile, our population has grown. And now this impacts all of us, as our land use policies have driven up home prices and rents to the highest in the nation that are too high for too many. The legislature passed the MBTA Communities Act to allow for the homes we need and to put Massachusetts on the path to a bright future where everyone can thrive. It is not optional. This is an all-hands-on-deck moment. The future of our people, our communities, our economy, and the Commonwealth are at risk. And rarely is a problem so solvable. The beauty of the MBTA Communities Act is that when all 177 communities comply, we are joining together to create the 200,000 homes across income levels that Massachusetts needs to stabilize our home prices and rents. No one community can do it on their own. It requires all of us to join in. And when we allow for housing production, there is so much good that happens. Grandparents can live near their grandkids. People can start businesses in their communities. People can stay in the communities where they grew up or where they raised their families. Our schools have teachers. Our Department of Public Works has people to maintain our town and plow the roads. And entrepreneurs can start the businesses that they've dreamed of. So Massachusetts really has a long history of establishing policies to enable housing production and preservation, starting with Chapter 40B, requiring every community to have affordable housing. We've built our own state public housing. We offer financial incentives, encouraging housing production around transit and around smart growth areas through Chapter 40R, the state's smart growth housing policy. And carrying through all the way to the Affordable Homes Act, passed this summer, that will now allow accessory dwelling units in every single community wherever single-family neighborhoods are established. So it will take many tools to create the homes that we need, and the state is putting these tools in place. It is up to our communities, where decisions are made every day on what can be built and what can't be built, to comply with this law to allow the homes that we need. We truly need everyone on this team using these tools to create the future that we all want and that we all deserve.
morning, and thank you, Attorney General Campbell, for your leadership in defending the MBTA Communities Law. I am here today on behalf of the business community. Associated Industries of Massachusetts is a community of 3,400 employees from every corner of the Commonwealth and every segment of the Massachusetts economy. And almost every employer that I have talked to recently has said that they either have an employee or a candidate for a job who has said, I really love it here, but I can't afford to stay here and I have to move my family somewhere else that's more affordable. The housing crisis impacts the economy and our workforce. The soaring cost of buying a home in Massachusetts is driving our best and brightest to less expensive regions of the country. I know this because I've lived it. I came to Massachusetts to attend college. I stayed, but it was challenging to pay rent. It was challenging to save up enough to buy my first home. And that was 20 years ago. Think what our young people are facing today. If Massachusetts wants a strong economy and employers want to compete for the talent in some of the fastest growing industries, then we have to be serious about housing now. And the numbers tell the story. Massachusetts last month had the 4th highest median home price in the United States, trailing only Hawaii, Washington, D.C., and Washington State. The median price is 50% higher than the national average. And we know that Boston ranks among the bottom 15 of metro areas when it comes to construction of new homes. One business owner who responded to a recent AIM Business Confidence survey spoke for her employees when she said, finding qualified workers is challenging, but even more so when my existing employees tell me they can no longer afford to remain in Massachusetts. The MBTA Communities Law is unique because it addresses not one, but 2 major challenges our economy is facing, housing and transportation. The law understands that there is a symbiotic relationship between the ability for people to find shelter and to get to work and home again, while at the same time underscoring the long-term economic prosperity of the Commonwealth. That's why this law has united the statewide business association known as AIM, the AFL-CIO, the Attorney General, and others here with me today, because we know that action must occur that will help us move forward. At AIM, we believe in the power of business to create a better tomorrow and a more prosperous and thriving Massachusetts for all. We believe that economic opportunity and prosperity are gifts from one generation to another, not a ladder to be pulled up as others attempt to climb on. AIM is proud to support the efforts to accelerate the supply of housing and moderate the prices our employees must pay to live and work here in the Commonwealth. Thank you.
Thank you. I'm now happy to take a few questions before I let you go, and hopefully you will mosey over to the courthouse. Any questions?
General, what are the implications if you do not prevail over the town of Milton, both in terms of the impact on housing, but also the authority that the state has to mandate what municipalities do?
There are significant implications. I'm confident that if the court, of course, hears our arguments, reads the briefs from 70 organizations and this diverse coalition, they will come out on the right side here and make it clear that the MBTA Communities Law is not only mandatory, but also a tool to address our housing crisis and even our transportation challenges. So I'm staying in a place of optimism, while also making it clear that if this court comes on the opposite side, or I think down with the wrong, comes out with the wrong decision, it not only will set us back in terms of addressing our housing crisis, it will do a significant damage to the rule of law and how we see it, how we view it, and how we depend upon it to allow one municipality, for example, to say that they don't want to comply. So I am confident that the court will take all of that in consideration today and, of course, when they're deliberating post this hearing.
Is there a concern that it would be then a domino effect, that more communities would sort of follow Milton's lead and not be in compliance?
I think so. This advisory that we put out in March of last year made it crystal clear. Not only is the law mandatory based on the language of the statute, based on deliberations by the legislature, the Democratic legislature working with the Republican governor to get this done. So if anything, I see the court, when they make this decision, and hopefully it is that this is mandatory to follow it, that it is just icing on top of the cake, right? Making it crystal clear to those municipalities that may still be confused what the law requires and what it demands in terms of compliance.
It sounds like Milton is putting together a compliance plan if they are on the wrong side of this ruling, the right side for you. I guess, how quickly would you want them to come into compliance? compliance if you are successful in this case?
As soon as possible, and I think that's reasonable to expect that. They actually had a plan that was compliant. They received resources from the state and funding to help with the planning process, to bring on technical, to have technical assistance, to bring on experts to inform that plan. And so I think they have everything it would take to implement a plan, even if they needed to tweak it. And one thing I want to stress, along with the folks behind me and Secretary Gustis and his team, is that the law is flexible. It understands that each municipality is different, and that each municipality may need to figure out which district, which part of their community is best to build the housing. It offers that flexibility, it offers that creativity. And when we were drafting and reviewing the regulations along with Secretary Augustus and his team, the regulations include that sentiment, but also that flexibility within them.
Assuming you're successful in this case, can other towns expect to see similar legal action if they're not compliant? I'm thinking in particular of Holden, which has said that it's not going to follow the law regardless.
I want to stress that right now, as of today, Milton is the only town and only municipality that is an outlier in that it is not compliant. Holden actually still has some time to come into compliance. So hopefully the court comes out with a decision that confirms our analysis, and that offers another tool for municipalities to rely upon to say the law is mandatory and we need you to come into compliance. And also for residents and planning boards and planners who are on the ground as a part of this organized effort to bring about more housing, for them also to have a tool and evidence that it's legally required, and to push their municipal leaders to do the right thing.
Is the hope that the court makes a decision quickly, and you hoping to have an opinion at speed here?
I hope so. Obviously, when we first went into court, we wanted this hearing today to be sooner. But we respect the discretion, of course, of the court. We will go into the court today with the team, who is amazing, and put forth our arguments, and hopefully they will return a decision sooner than later.
Last question. No? Great.
Thank you all very much. Thank you.
Thank you.
Thank you all very much.